A nearly 20-year-old extradition treaty between the U.S. and UK has been brought up at the Woolwich court, where Julian Assange's fate is being debated. Attorneys for the embattled journalist citing the Anglo-U.S. extradition treaty, which expressly prohibits extradition for political offenses. Now, the question is then, will the judge view this as such? For more on this, we'll talk with former UK MP and friend of Julian Assange, George Galloway, who has also recently wrote an op-ed on Assange's case on RT.com. You're looking at it right there. All right, George, do you believe that there's a chance that Her Majesty's Court may take these facts into consideration and follow suit with the Queen herself and rule this a political matter, therefore not one for this criminal court?
Well, it started out as tragedy, but it's descending into farce now. To such an extent, I have to wonder if the British authorities are deliberately seeking a mistrial, because every abuse of process that could possibly be accumulated in a British courtroom has taken place already, and it's only Thursday. The whole saga of Julian being in a bulletproof box and not able to confer with his legal team, despite both the defense and the prosecution asking that he should be allowed to do so, is still unresolved, with the judge saying that they'll have to apply for bail if that is going to happen, because she said Julian Assange might constitute a danger to the public. That's in an armed courtroom, flanked by security guards, in a terrorism court connected by tunnel to Britain's Guantanamo Bay, in which no member of the public can get anywhere near Julian Assange. She said it was a health and safety issue and that she could not order it in any case. Only Group 4 security, a private security company, could do it. This on top of the multiple layers of abuse of process that have already been established, from the filming of Julian's legal consultations with his lawyers inside the Ecuadorian embassy by the CIA, which works for the government, which is trying to extradite the prisoner in question, and goes through so many layers. You don't have enough time for me to adumbrate them fully. But the higher courts in Britain, to which this will now repair, if we assume that this kangaroo court is going to turn down Julian's defense, award extradition to the United States. This will be appealed to higher levels of the British judiciary. And I've got to tell you, you may think I'm naive, it's almost impossible for me to believe that proper judges in more senior courts in Britain could possibly allow this.
Now, George, I am absolutely shocked that the judge would say Julian might pose a threat to the public in some way, unless she knows that he's somehow contracted coronavirus or something, so he has to be isolated in this glass box. I'm baffled by this. But, George, the charges against Assange are along the lines of criminal hacking. So, I mean, not only does that not pose a physical threat to the public, but how is the U.S. government attorneys going to prove that? We're still arguing the same thing.
Yes, it's quite clear that these are political offenses. All but one of them are under the Espionage Act in the United States, which is ipso facto a political matter in British law, and the lawyers for Assange have laid out all the cases that are covering this kind of area. And so if they are political offenses, they are, as I told you weeks ago, I think, under the extradition treaty, he cannot be extradited for them.
Yes.
It's written on the face of the treaty. It's point 4.1. It's 4.1 on the face of the extradition treaty. So the government are reduced to arguing that although it says that in the treaty, and you can't extradite someone unless you have a treaty, otherwise we'd be extraditing people to China and Saudi Arabia and so on, because we have no extradition treaty with them, that this will not apply in this case, because British law does not exclude extraditions for political purposes.
Well, George,
but the British law in question is superseded by the treaty 4 years later. And so, as one who got assurances from the man who signed the treaty, David Blunkett, the former Home Secretary, I was a member of Parliament at the time, he gave me the assurance, he pointed to 4.1 as the reason why I should not be concerned. Well, I mean, who wrote this script?
Well, George,
Kafka?
Pardon my interruption. Pardon my interruption here, but I'll get the viewers up to speed here. This is a 2003 extradition treaty. It appears to be very one-sided. The agreement seems to give the U.S. broad powers of requesting people from the U.K. over to the U.S., even if the crimes were never committed on American soil. But this rule doesn't apply the other way around, George. So why then would the UK enter into such an agreement?
Well, because we are an offshore island, effectively a part of the United States, certainly at the time under Tony Blair, and it was his government that drew up this one-sided extradition treaty. No free country in history has ever signed a more one-sided extradition treaty. The United States would never allow, and never has allowed, the extradition of any of its citizens accused of political crimes to any other country in the world. And if taking back control was the aim of those who wanted to leave the European Union, they've got a strange way of showing that we've taken back control by effectively acting in obeisance to the United States government in this affair. I still believe, I may be the last man standing who believes, that higher levels of the British judiciary will never put up with this, which would be not just a national humiliation, but the murder in plain sight, on our watch, of journalism in the world.
All right, we'll have to leave it right there. I want to remind the viewers to check out George Galloway's op-ed at RT.com. You'll read all about this case there. George, as always, appreciate your time. Thank you.